Hello and good whatever time of the day it is, wherever you are watching this. Today's presentation will be primarily for employers, but it's also going to be helpful if you are an employee, especially if you are one who is potentially facing a termination or recently was, as well as if you are planning to resign. Here are the obligations that your employer should be following. Now, this is designed for employers in California, which is a very adventurous state if you are an employer. A lot of challenges that you are going to have to undertake if you are a California employer. As you know, I also do California landlord tenant law, and in several areas, employers are in a similar category as California landlords. Now, it's never an excuse to not know and understand the law. If the law is in place, you are expected to know it. So, this is why, as an employer, you should be familiar with these procedures as well as these liabilities if you don't follow proper procedures in California. As I always say, don't learn the law as a defendant. Okay, final pay. So, whenever a California employer terminates an employee, all wages and unused vacation days become due immediately upon the final workday. Now, I'm talking about when a California employer terminates the employee. I'm not talking about when the employee resigns, quits, retires, etc. I'll talk about that in a later slide in this presentation. So, for example, if you terminate your employee at 3:30 p.m. today, you cannot promise to pay that employee tomorrow or next week. The final pay that you are going to owe the employee that you are terminating today must be paid at or before that final moment of termination. So as long as you're paying it at the same time, then you're good. If it's, a little fuzzy as to whether it was a few minutes before or after, probably not so big of a deal. But the main distinction is if you're terminating the employee and then telling the employee to come back later to get their stuff and then you'll bring the paycheck, that is a problem. Oh, and on that previous slide, what I have here is an example of a final paycheck acknowledgement. Now, this is just a sample template, but what I recommend you use when you are either terminating an employee or the employee is terminating themselves by quitting is a mutually signed mutual acknowledgement of all the money that was paid to the employee, which represents the full and final satisfaction of all wages owed. Now, if you're an employee and you're watching this, do not feel pressure to sign this. They can't withhold the payment to you that you're owed contingent upon you signing this. If you don't understand it, if you don't agree with it, don't sign it. Have ideally a lawyer that you can call. And if you're in San Diego, oh, you're in luck because so am I. So have a competent California employment or labor attorney that you can call if you have concerns before you sign an agreement, because as soon as you do, you are putting yourself in a similar position as many landlords or employers who say, well, I didn't understand what I was agreeing to. Well, don't sign anything if you don't understand what you are signing. Next, so even if the terminated employee owes you money or equipment or keys, you cannot withhold the employee's earned and unpaid compensation contingent upon them paying you or returning anything that they owe you, whether it's keys, whether maybe they owe you money. Be careful if they owe you money. You still are better off giving them their full and final salary and any wages or commissions, compensation, bonuses that they're owed, and then deal with the money they owe you later, perhaps in a small claims suit if it's under $5,000. Now, keep in mind, small claims is normally $10,000 unless you are an employer. In other words, unless you're an LLC. Now, you know, when I said employer, most employers, not all, but most are incorporated, and a business can sue for no more than $5,000 in small claims. And there's reasons for that, such as they're assuming that the employer is generally more sophisticated and more monetarily capitalized, where they can afford to file in superior court. It also gives the other side a chance to use an attorney when you file in superior court. But in small claims, if you're a corporation, In other words, if you're an LLC, an S corp, a C corp, you cannot sue for more than $5,000. Similarly, there's other restrictions depending on how many times you've sued, but that's the main thing. So go after the employee for anything they owe you at a later time. Just protect yourself, because as you'll see, there are strict timelines, and it's even stricter when you, the employer, are the one that's terminating the employment. Now, if you wait to pay any of the employee's earned and unpaid wages until after the employee's termination date, then under sections 201 and 203 of the California Labor Code, an employer can face waiting time penalties. There's statutory penalties if you don't pay your employees and soon to be former employees the full amount by the final termination date. All right, so when the employee quits, now we're going to be changing topics. Before I was talking about when the employer is initiating the termination. Now I'm talking about when the employee is initiating termination. And this is known informally as the 72-hour rule. All right, so don't necessarily look this up by the 72-hour rule. It's just a rule of thumb that I use. And it's as follows. So it applies when the employee is giving notice that the employee is terminating employment. And it looks at, did the employee provide at least 72 hours notice prior to quitting, or was it fewer than? So it's generally preferred that the employee provides the, cliche 2 weeks notice prior to quitting, but that's frequently not done. It's not a statutory requirement, and it's obviously not always practical when tensions between the employer and the employee are high. And tensions are probably going to be a little bit more than baseline if we're having this conversation. The employer is considering terminating the employee, or the employee is considering terminating the employment relationship. So, under California Labor Code, Section 202, when an employee provides at least 72 hours notice prior to quitting, then the employer must pay all wages and earned vacation owed on the final day of work. So it's as if the employer is terminating the employment for the sake of this timeline. If the employee gives at least 72 hours, basically 3 days, and that's not 3 business days, that's not 72 hours on your business calendar, that's 72-hour calendar days. And don't add extra time for holidays or weekends. 72 hours. So if the employee quits with fewer than 72 hours notice, then the employer is still obligated to pay all the earned but unpaid wages and vacation. However, now the employer has, within 72 hours after the employee's notice, and that employee's notice should have been given to the employee's agent or the employee um, supervisor or the employer directly. But as long as they quit with 72 hours or fewer, then the employer has 72 hours, up to 72 hours, to provide the final pay and final compensation. And to clarify, if it's fewer than 72 hours, if that employee gives that notice. If the employee gives 72 hours or more, then that's the distinction. Okay, so it's fewer than 72 hours or 72 hours or more. And if, to recap, if it's fewer than 72 hours, then the employer gets 72 hours after that notice was tendered to provide the final pay and compensation. If it was more than 72 hours that the employee gave notice, then it's due the same day. In other words, the same day of the final day of work. And that will have been articulated to the employer. So if the employee gives notice on Monday and it's given properly, then if the employee says, I'm going to quit on 5 p.m. on Friday, that's more than 72 hours, and that's fine. Therefore, at 5 p.m. or before, that employer should be prepared to provide the final pay, the final wages, final compensation, final commission, whatever is earned and owed. Now, there's a few exceptions. We'll talk about that in a minute, such as commissions. But for now, understand the rule before you focus on the exceptions. So, how do you calculate the 72 hours and use that rule? Well, it's based on the clock, not business hours. So, the most you could wait is 3 calendar days, not 3 business days. And don't assume that a holiday will give you more time either. Now, where do you send the final paycheck? Well, that depends on a couple things. So if you terminate the employee, you are not surprised by this termination. You are the one initiating it. Therefore, if you terminate the employee, you need to provide the earned and unpaid wages to the terminated employee at the place where the employee resides at the termination time. In other words, this is based on the employee's location, not the employer's. Now, if the employee quits with at least 72 hours notice, then you need to provide the final payment to the employee at the office or location where the employee had been working. And if the employee quits with more than 72 hours notice, then you should still provide the final payment to the employee if practical, but you're also entitled to mail the check. But be mindful that mailing, especially if you mail it on a Friday, could risk running afoul of that 72-hour rule. Now, what if the employee works remotely, which is more and more common since 2020? So, if okay, so I had to take a quick pause to answer a call. If you terminate the employee and the employer works remotely, then you have to provide the final payment at the employee's location no later than the moment you notify the employee of the termination. But what if that employee is working out of state? You're supposed to travel to like Nebraska to do it? Not necessarily. If the employee had previously elected to be paid by direct deposit and had been paid in the most recent paychecks through direct deposit, then you can pay the final wage to the employee so long as you observe those normal timelines. Now, look at California Labor Code section 213, specifically section 213 subsection D, to make sure you're compliant with those rules. Now, there was a case that you might want to look up, Smith versus the Superior Court of Los Angeles County. I'm not going to spend much time on it now, but look at the holding. It's relevant to what we're talking about. Next, don't try to use a suspension in lieu of a termination. So, what some employers have done is if they didn't want to or didn't have the ability to pay the employee at that final date of work, what they tried to do was, we're going to suspend you. And then they ended up never using that employee again. That essentially their final workday was Monday, June 1st, but they said you're suspended until June 10th, and then we'll decide whether we're going to pay you or not. That's very risky. What they should have done is paid them on June 1st, or if they're going to suspend them, then at least hire them for one or more days. Still not going to totally protect you, but it's a better idea than using just a blank suspension and not having a definite resumption of work prior to the final day of pay. That could get you in trouble if you're not careful with that final pay rule. Now, expense reimbursement. So, expenses that are to be reimbursed to the terminated employee are treated differently than wages and vacation. Now, wages and vacation always have to be paid at the time of termination if you are terminating the employee, or at the time of termination if the employee gave notice of resignation more than 72 hours, at least 72 hours or more, or within 72 hours if the employee tendered the resignation notice fewer than 72 hours prior to their final workday. But for expense reimbursements, reimbursable expenses do not fall under the 72-hour rule, and they can be paid per the normal reimbursement timelines. So, what about commissions? Well, if the commission had already been earned but unpaid at the time of termination or resignation, then it must be paid. But if the commission payment is contingent upon a future event happening, such as the completion of a customer's order or receipt of the customer's payment, which has not yet happened, then according to the California Labor Commissioner, these type of wages will normally fall outside of the normal rules for final wage payments. Now, the final pay worksheet is really important because tensions are probably going to be high at the time of the termination or resignation. And whenever emotions are high like this, the termination, when emotions are high for moments like this, the likelihood for misunderstandings is going to be usually mediocre, moderate to extremely high, and it's usually the latter. So here's one method to mitigate the foreseeable misunderstandings, and that's the use of a final paycheck worksheet to be completed by the employer. And the final paycheck worksheet will make it much clearer for both parties to confirm the nature of the separation and see the math behind the calculation of the employee's final paycheck, both in terms of wages and deductions. And furthermore, the final paycheck worksheet makes it clear whether this termination of employment was involuntary or voluntary, and if so, whether the employee gave more than 72 hours of notice or less. Now, the main purpose of this final paycheck worksheet is to mitigate the risks of an improper termination or withholding claim against the employer. And If one is inevitable, such as an improper termination claim, then this will provide a degree of protection to the employer. It shows exactly how they broke down the math versus just not showing your work. And then final pay acknowledgement. So this is extremely important. Even if you don't do this final pay worksheet, which you should, you really should, if not must. It's not a requirement, but I really strongly urge every employer to do a final paycheck acknowledgement. It's not that the employee is always willing to sign it. And again, like I said at the beginning, if you're an employee, you don't have to sign either of these. But if you are an employer, you should try to get everything filled out on some kind of similar final paycheck acknowledgement and then get the employee to sign. And that acknowledges, whether in this language or something similar, to the best of my knowledge, there is no additional money owed to me by the employer at the present time. Now, if you can get the employee to sign it, great. If you can't, then sign it yourself. And that will provide a reasonable degree of protection. All right, wrapping up, final suggestion. So before you terminate an employee, it's best to have laying the groundwork for reasons leading up to the termination to avoid claims of discrimination, to avoid acting arbitrary and capricious. You want to show that there was a pattern and practice of missing work, being late to work, incompetence, argumentativeness. Be extra careful when terminating an employee if the employee has recently lodged a complaint against you or a government agency alleging anything, but especially alleging improper payment of wages, because that could be seen as retaliatory and subject you to liability. So make sure that you are terminating the employee for reasons completely unrelated to the wage dispute and provide substantiating evidence to corroborate this assertion. Now, make sure you deduct all of the typical deductions from the final paycheck as you normally would. And in other words, don't accidentally pay the employee with gross pay instead of net pay like you normally should. But also make sure all the deductions, as you saw in this final paycheck acknowledgement, are clearly laid out. Otherwise, it might look like you are not paying their Medicare, unemployment tax, etc. So make sure that that's clear. And you might be asked to pay unemployment pretty soon. It might come out of your fund. So make sure that you are terminating the employee for reasons completely unrelated to any potential wage dispute that actually was or could be raised, and provide substantiating evidence to corroborate this assertion, such as, like, this is why I'm terminating you at this time. And you don't have to say at this time, it's usually permanent, but let them know for the reasons, such as, and make it clear, put it in writing. People like to put things in verbal communication, and that is a recipe for misunderstanding and miscommunication. All right, I'm gonna take a pause one more time. All right, sorry, had another phone call. So you might also want to include a final pay stub, totally optional. You don't have to do this, but include a final pay stub that shows all payments made to that employee for the year, as well as any other documentation that they will need when it comes time to file their taxes, so they don't have to reach back out to you. Basically, if you are terminating an employee, you probably don't want to have an ongoing relationship with them, and they probably feel the same way about you. So give them everything that you can give them at the time. Obviously, not all the documentation will be finalized and ready, but whatever you can to make it hopefully less likely that they'll have to have follow up communication with you. All right, so that has been my overview of what I believe you should do as an employer when you are terminating a problematic employee in California, for California employers and California employees. This is for information only. This is not specific legal advice for you. If you do need specific legal advice for your California company or California apartment complex or single family home, I am licensed in California. I specialize in residential real property, especially landlord tenant. I also have a subspecialty for employment law, and the two often converge where you have several people managing a multifamily apartment complex and you have employees. So that's why this falls under the purview of California landlord tenant. If you found this helpful, please let me know. If you didn't, please let me know as well. Let me know what I can do to improve, or let me know what you liked. And if there's another topic you think I should cover, please let me know. It'll help me help you. Thank you.